Namaste everyone. Welcome to Part 4 of Live Law's limited series on the most important judgments delivered by the Supreme Court in 2021. Subscribe to Live Law and watch the previous videos if you haven't already. In today's episode as well, we'll cover 20 judgments, so let's dive right into it. The Supreme Court on 6th August ruled in favor of e-commerce giant Amazon in its dispute with Future Retail Limited over Future Retail's merger deal with Reliance Group. The top court held that the emergency award passed by Singapore arbitrator restraining the Rs 24,731 crore amalgamation deal between Future Retail and Reliance is enforceable in Indian law. The court held that an order of enforcement of an emergency arbitrator's order made under Section 17(2) of the Arbitration and Conciliation Act is not appealable under Section 37 of the Act. The court also upheld the order of the single bench of the Delhi High Court, which had ruled in favor of the enforcement of the emergency award and held that single judge's order was not appealable to the division bench of the High Court under Section 37, subsection 2 of the Arbitration Act. The Supreme Court has observed that the judgment in National Insurance Company Limited versus Pranay Sethi, reported in 2017, Volume 16, Supreme Court Cases at page 680, does not limit operation of a statutory provision granting greater benefits in the matter of motor accident compensation. If a statutory instrument has devised a formula which affords better or greater benefit, such statutory instrument must be allowed to operate unless the statutory instrument is otherwise found to be invalid, the bench of Justices U. Lalit and Ajay Rastogi observed. The Supreme Court observed that deposit of fine amount cannot be made a condition precedent for hearing revision petition under Section 397 of the Criminal Procedure Code. In this case, the accused was convicted for the offence under Section 138 of the Negotiable Instruments Act and was sentenced to fine in the sum of Rs 6 lakhs. An amount of Rs 5.9 lakhs was directed to be paid to the complainant as compensation in terms of Section 357 CRPC, and the balance amount was to be remitted to the state. The appellate court dismissed the appeal filed by the accused. This was challenged before the High Court by way of a revision petition. The High Court ordered that the criminal revision petition shall not be entertained unless the fine amount is deposited by the accused. Setting aside this order of the High Court, the bench of Justices Vineet Saran and Dinesh Maheshwari observed that the High Court could not have made the deposit of fine amount a condition precedent for the purpose of hearing the revision petition. The Supreme Court expressed exasperation at the delay on the part of the Union government in filling up the mounting vacancies of judges in high courts across the country. In an order passed on August 9, 2021, the top court had observed that the recalcitrant attitude of the government in not appointing high court judges even years after the Supreme Court Collegium had cleared the recommendations was causing delay in adjudication of cases. A bench of Justices Sanjay Kishan Kaul and Rishikesh Roy made these serious observations while hearing a special leave petition filed against an interlocutory order passed by the Delhi High Court in a matter related to anti-dumping proceedings. With the objective of decriminalization of politics, the Supreme Court on 10th August 2021 directed that political parties must publish the criminal antecedents, if any, of the candidates within 48 hours of their selection. A bench of Justices R.F. Nariman and B.R. Gavai modified the directions in its February 13, 2020 judgment in that regard. In para 4.4 of the February 2020 judgment, the Supreme Court had ordered that the details shall be published within 48 hours of the selection of the candidate or not less than 2 weeks before the first date for filing of nomination, whichever is earlier. The court also directed the Election Commission of India to create a dedicated mobile application containing information published by candidates regarding their criminal antecedents so that at one stroke, each voter gets such information on his or her mobile phone. The Supreme Court observed that there is no residual equity-based jurisdiction in the adjudicating authority or the appellate authority while dealing with the resolution plan approved by the Committee of Creditors. The bench of Justices D.Y. Chandrachud and M.R. Shah reiterated that these authorities cannot enter into the commercial wisdom underlying the approval granted by the COC to the resolution plan. The Supreme Court held that a foreign award can be binding on non-signatories to the arbitration agreement and can thus be enforced against them. In this regard, the court referred to Section 46 of the Arbitration and Conciliation Act, which deals with the circumstances under which a foreign award is binding. The court noted that the provision speaks of persons as between whom it was made and not parties to the agreement. Persons can include non-signatories to the agreement. The bench of Justices R.F. Nariman and B.R. Gawai further observed that perversity of an award is not a ground to refuse enforcement of a foreign award under Section 48 of the Arbitration and Conciliation Act after the 2015 amendment. The court held that the ground of patent illegality is only available to set aside domestic arbitration awards made under Part 1 of the Arbitration and Conciliation Act and will not apply to international commercial awards. Right to shelter does not mean right to government accommodation, the Supreme Court observed, while setting aside a Punjab and Haryana High Court order which allowed a retired Intelligence Bureau officer to retain government accommodation. The court observed that government accommodation is meant for serving officers and officials and not to the retirees as a benevolence and distribution of largesse. The bench of Justices Hemant Gupta and A.S. Bopanna added that compassion, howsoever genuine, does not give a right to a retired person from continuing to occupy a government accommodation. A retrospective provision in a tax act, which is for the removal of doubts, cannot be presumed to be retrospective, even where such language is used, if it alters or changes the law as it stood earlier, the Supreme Court observed, while holding that Explanation 3 capital C to Section 43 capital B subclause D of the Income Tax Act is clarificatory and does not add a new condition retrospectively. The bench of Justices R.F. Nariman and B.R. Gawai observed that Explanation 3C was introduced to curb the misuse of the provisions of Section 43B by not actually paying interest but converting such interest into a fresh loan. The Supreme Court observed that there cannot be a repeated test identification parade till such time that the prosecution is successful in obtaining identification of the accused. The bench of Justices Naveen Sinha and R. Subhash Reddy observed that mere identification in the test identification parade cannot form the substantive basis for conviction unless there are other factors and circumstances corroborating the identification. It reiterated that a test identification parade under Section 9 of the Evidence Act is not substantive evidence in a criminal prosecution but is only corroborative evidence. Repeated inquiries for verification of caste certificates would be detrimental to the members of scheduled castes and scheduled tribes, the Supreme Court observed. The bench of Justices L. Nageshwar Rao and Anirudh Bose said that the purpose of verification of caste certificates by scrutiny committees is to avoid false and bogus claims, and reopening of inquiry can be done only in case they are vitiated by fraud or when they were issued without proper inquiry. The Supreme Court observed that while accepting charge sheet, the magistrate or the court is required to invariably issue a process of summons and not a warrant of arrest. The bench of Justices Sanjay Kishan Kaul and M.M. Sundaresh also observed that if an accused in a non-bailable offence has been enlarged and free for many years and has not even been arrested during investigation, it would be contrary to the governing principles for grant of bail to suddenly direct his arrest merely because the charge sheet has been filed. The Supreme Court on 18th August 2021 held that Section 170 of the CRPC does not impose an obligation on the officer in charge to arrest each and every accused at the time of filing of the charge sheet. A bench of Justices Sanjay Kishan Kaul and Rishikesh Roy observed that the practice of some trial courts of insisting on the arrest of an accused as a prerequisite formality to take the charge sheet on record is misplaced and contrary to the very intent of Section 170 of the Criminal Procedure Code. The Supreme Court observed that adjudicatory function of the National Green Tribunal cannot be assigned to committees. The discharge of its functions cannot be obviated by tasking committees to carry out a function which vests in the tribunal, the bench of Justices D.Y. Chandrachud, M.R. Shah and Hima Kohli observed. In this case, the NGT merely based its conclusion of constituting a committee on the statement which was made by the project proponent and had not conducted an independent appraisal of the grounds of challenge. The top court allowed the appeal against this order and directed the NGT to reconsider the appeal afresh. The Supreme Court held that until and unless the railways provide evidence and explain the late arrival of a train to establish and prove that delay occurred because of the reasons beyond their control, they would be liable to pay compensation for such delay. With this view, the court upheld the order passed by the NCDRC, whereby it had confirmed the original order passed by the District Consumer Disputes Redressal Forum, ALWAR, allowing the complaint filed by the respondent in the present matter and directing the North Western Railway to pay for taxi expenses, booking expenses, along with expenses towards mental agony and litigation expenses. The Supreme Court on 7th October 2021 declared that the National Green Tribunal is vested with suo motu powers to take cognizance on the basis of letters, representations and media reports. A bench of Justices A.M. Khanwilkar, Rishikesh Roy and C.T. Ravikumar delivered the judgment on a batch of petitions which raised the issue of whether NGT has suo motu jurisdiction. The court held that the NGT must be seen as a sui generis institution, as the National Green Tribunals Act 2010 provides the tribunal with wide-ranging powers beyond that of a mere adjudicatory body. The court also acknowledged that environmental impact on climate change is gaining increasing visibility in recent times, and the NGT must be given the discretion to exercise suo motu powers in order to salvage adverse environmental consequences for generations to come. The Supreme Court held that a Director of Enforcement can be appointed for a period of more than 2 years by following the procedure prescribed under Section 25 of the Central Vigilance Commission Act 2003. The bench of Justices L. Nageshwar Rao and B.R. Gavai also upheld the power of the Union of India to extend the tenure of the Director of Enforcement beyond the period of 2 years. It clarified that the extension of tenure granted to officers who have attained the age of superannuation should be done only in rare and exceptional cases. The court is delivering its judgment in a PIL that challenged the extension of tenure given to ED Director S.K. Mishra. The court, however, held that S.K. Mishra's tenure should not be extended further. The Supreme Court held that magistrates would not be competent to extend the time to complete investigations in UAPA cases. The only competent authority to consider such request would be the court, as specified in the proviso in Section 43 D 2B of the UAPA. The bench of Justices U. Lalit, S. Ravindra Bhatt and Bela M. Trivedi held. In this case, the Chief Judicial Magistrate Bhopal had granted extension sought in an application moved by the investigating machinery under Section 43 D2B of the UAPA. Also, the accused's application seeking bail on the ground that no charge sheet was filed by the investigating agency within 90 days was dismissed. The High Court upheld these orders, observing that since the CJM Bhopal had passed an appropriate order, the period available for the investigating machinery to complete the investigation stood extended to 180 days, and as such the applications preferred by the appellants under Section 167, subsection 2 of the Code were not maintainable. Against this order, an appeal was preferred before the Supreme Court, which was allowed. The Supreme Court has observed that bank account of a person accused under Prevention of Corruption Act cannot be attached invoking Section 102 of the Code of Criminal Procedure. It is not possible to sustain the freezing of the bank account of the appellant, taking recourse to Section 102 CRPC, as the Prevention of Corruption Act is a code by itself. The bench of Justices Sanjay Kishan Kaul and M.M. Sundaresh observed, while allowing an appeal against a Karnataka High Court judgment. The Supreme Court held that Section 54(3) of the Central Goods and Services Tax Act excludes unutilized input tax credit that accumulated on account of input services. When there is neither a constitutional guarantee nor a statutory entitlement to refund, the submission that goods and services must necessarily be treated at par on a matter of refund of unutilized input tax credit cannot be accepted, the court observed while rejecting the challenge against Section 54(3) on the ground that it violates equality doctrine under Article 14 of the Constitution. The bench of Justices D.Y. Chandrachud and M.R. Shah set aside the Gujarat High Court judgment, which held that Rule 89(5) of the Central Goods and Service Tax Rules 2017, by restricting the refund only to input goods, had acted ultra vires Section 54(3) of the CGST Act. It approved a Madras High Court judgment which upheld the rule. With this, we've come to the end of today's episode. So far, we've covered 80 judgments and we only have 20 more to go. So stay tuned for the last episode of our series. I'm Tanya Pandey for Live Law and I'll see you again very soon. Have a beautiful week ahead.